It's an everyday thing. It's an everyday thing. It's an everyday thing when you let your nuts hang.
What it do, everyday people, man? It's your boy PJ. Today we back with another lit video. Back in the confessional, and yeah, we staying lit, big dog, man. Shout out to my everyday people who rock with me every day. And shout out to my homie Lucky Wizard Deals. He keeps it lit. And shout out to the Wolf Packet Cool Kid, the So Cool fam, Big Nike PRP, and Living by Lexi, and all that good stuff, man. We got another court update. This is for Lamont Butler, okay? Also in coercion with Raven Queen. Now, Raven Queen and Lamont Butler's, their trial is set for November 6th. But I don't think Lamont gonna make it. I do not think he gonna make it. The man is ready to tell it all. He's ready to spill the beans. Reason why? Well, this hearing is to dismiss some video evidence, which evidence they found on Lamont Butler's phone. Okay, explain that. Now, I'm not going to be actually showing the video because it's really not nothing. It's just people talking. So just listen and we'll react to it, man. It's really a listen and learn, okay?
Mr. Butler is present in custody with Mr. Sheets. This is the time set for a motion and notice of intent to admit video evidence. What's your position, Mr. Sheets?
If Your Honor would be willing to grant me the opportunity to file a written opposition, I would like the opportunity to do that. Otherwise, I mean, I do have significant notes and can oppose orally, but I'd essentially be reading a speech that we wrote that would be superimposed into a written opposition anyways.
Okay, so it heard arguments and ruled on the others, so let's just proceed with oral argument.
Yes, Your Honor. So from the standpoint, so is the state going to go first? Is there a motion? Or I assume they've already gone first.
State, is there anything you want to add to your written effort at this time?
I mean, just this would be the person whose phone it is. So this is the person's phone. That's all.
Okay, so this is the phone that was damaged but recoverable.
Yes.
And this is the link to everyone else that we already talked about. Okay, go ahead.
Yes, Your Honor. From what we gleaned, the two specific issues, bad acts or alleged bad acts that are at issue, are text messages in the group chat between the co-defendants regarding electric consignments from California, and videos recorded by a co-defendant supposedly casing a house that was not ultimately burglarized, and videos were sent to that chat. Our concern is, as we go through, the state concedes these aren't necessarily crimes, and the prejudice is low in the analysis. The probative value would be low in the analysis. While our client is involved in the chats, and they may have been found on his phone, his involvement is much less significant than many or some of the other co-defendants. And that's one of our biggest concerns. Also, our concern is, if it comes in towards other co-defendants, we're going to lead down the possibility of a needed obvious severance in this particular circumstance. Because what it does is it essentially is evidence that would be much stronger, or uncharged evidence that would be much stronger against other co-defendants being construed negatively against my client simply because he was minimally or non-participatory, and it just happened to be found on his phone versus somebody else. As Big Pond establishes, the state's obligated to prove prior bad act is relevant to the crime charges and for a purpose other than proving propensity, and that it's proven by clear and convincing evidence, and its probative value outweighs the danger of unfair prejudice. We don't think the state can satisfy these factors. The video recording in this particular case has no direct connection with Mr. Butler. It's of Defendant Queen. It was recorded by Defendant Queen. She was alone when it was recorded in her car. It was sent to a brief text that just happened to have the co-defendants in it. She sends it at 4 o'clock on January 16th. Defendant Washington sends a message to the same group at 4:12. Defendant Queen responds and sends another message. Defendant Lee responds. Nowhere in this thread is Mr. Butler interacting with or reacting to the video that's sent by Defendant Queen. In fact, he's not involved in the text thread until two days later when he sends a message that is unrelated to the Queen video on January 18th at 10:54:59, 2023. It's our position the state can't prove by clear and convincing evidence that Mr. Butler himself had any direct involvement with the video before, during, or after its creation. And in admission to that would be making that presumption, given that he didn't have any reaction to or participation in the text chain. And what this ends up doing is ultimately takes conduct that he did not participate in with the others, and then attributes it or associates the guilt of that supposed conduct with him when he's not even in the same state, and there's nothing in that thread that would imply that he was encouraging of bringing forth that conduct or responding to or participating in any subsequent conversation that brings up. While not a physical presence, the state may try to argue that his inclusion in the group text is in a sense a digital presence, and the court. But what we have to understand is that in many situations, mere presence is a defense to actual unlawful conduct, and so I mean I would just refer Your Honor to kind of the standard cases on that: Skinner versus Sheriff, La Vestida versus State, Egan versus Sheriff, that all talk about when a defendant's physically present and somebody's engaging in conduct, and that defendant has had no actions or no conduct that has boosted that position, supported that position, given an impression that he's participated in that act, or that there's a conspiracy of any kind in that circumstance, would not be sufficient to stand up. And in this situation, this is similar to, but even better than that, because he's across state lines, and the state hasn't made any allegations or presented any evidence as to who created this particular group text, or who created this group, because you can involuntarily be caught up in group text messages. I have gotten them, quite frankly, advertisement group messages that'll be sent to me and 14 other people, and I'm like, who the heck are you, and why is this on my phone? So without anything else to link him to supporting that type of conduct, which I think by the state's own concession is not an actual criminal act, this stretches the boundaries, I think, too far. While the ownership of the phone has been attributed to Mr. Butler, there are also questions about whether or not he had exclusive possession of the phone. It was found at the address with Mr. Butler, Defendant Queen, Defendant Washington, Defendant Lee. All of them were there as well at that time, so it's very possible they could have been interacting with the phone as well. The Queen video depicts a random home located in Clark County, not the home in this case that's burglarized. So there really is no probative value in that towards this charge, and it's not a charged crime. It's not a crime because it's not. I mean, it's not only not a charged crime, the video, but it's not a crime at all. Taking the video is not a crime. The state fails to prove any probative value as the text messages regarding a consignment store in California has any relation to this case here, or that was constituting a crime. And the state, even though the state contends the messages between Butler, Queen, the others prove they were planning to sell bags stolen from the Kingsgate court residence, they have failed to provide any evidence that that is the case, or that it was actually done, that any bags were sold at the consignment store, that anybody actually interacted with that consignment store, or that bags stolen from there were in any way, shape, or form even moved in that direction. There really is no probative value reference to a random consignment store in California when there's nothing to show the connection between the store and Mr. Butler.
I think the state's asking to admit that consignment store necessarily as the bad act here. It's mostly just the connection.
The consignment store, if you think about it, Judge, would actually probably be still further into conspiracy because they aren't caught yet and they're trying to fence the property that was taken. That's not necessarily what this motion is.
Right.
That was under the remember how earlier I made the comment about identity for authentication purposes? That was kind of what that was in order to show the group.
Okay.
So what I'm getting from here is, man, Lamont lives in California, okay? He frequents back and forth to Las Vegas with Raven Queen, Derek Roberts, and the rest of them. Derek Roberts, who's already convicted up to 18 years. They sentenced him to up to 18 years, so he has to do 3 years. He has to do 3 to 5, 3 to 5, 3 to 5, and like a 3 to 5, something like that, or something, or 3 years. So he gets parole. He can get parole every 3 years, or he'll have to finish out a 5-year sentence. Then he'll go to his next sentence. 3 years, can parole out, or do 5 years. Then he can go to his next sentence. 3 years and parole out, or do 5, and then he has a 3-year sentence. So that could be, or something like that. Yeah. 18 years, up to 18 years, but as little as 12 at the least, right? 85%, because this is a violent crime. So now you got Lamont, who I believe will snitch or take a plea deal, because he does not want to be included in the entire scope of the crime, where Raven Queen was out filming other homes and sending them back to everyone in a group chat. All 5 of the defendants were in this group chat. And I know his conspirators, they looking at him side-eyed like, man, you about to, he trying to throw them under the bus, like, and his lawyer is really the one doing it. Is like, well, if you didn't respond to this message, then you have no involvement with this particular crime that did not happen. So he wants to omit that stuff from his case and wants to have a separate trial outside of the other 5, because he doesn't. But the 5 are being convicted for the CJ So Cool and others. But of course, the house that they got the video from that shows that they were conspiring to break in homes was found on his phone. Then his lawyer goes to say, well, my defendant, the phone was found in a home where everyone is, and everyone had access to that phone. Even though it was the defendant's, other people were using it. So he's just trying to say some other people were talking on his behalf, not him. So that's kind of the Gunna way of going out, and I think he'll take a plea deal. I don't think he'll take this to trial. In fact, I think all the young ones would, even though they're being charged as adults. They're being charged as adults. It's like, it's no doubt. When they release this court video evidence, all of them being charged as adults. You know what I mean? So, the younger ones may stay in a juvenile prison until they're old enough to go to an adult prison, but the rest of them will be going to, if they 17, they going to adult prison. At this point, they've been in jail for approximately 6 months, so maybe a birthday will pass, or 1 or 2 birthdays will pass before their November 9th birthday trial date. They'll all be 17, except for one who is still being tried as an adult, but he will remain possibly in a juvenile facility until his 18th birthday. And that's just what it is. So there you have it. Let's finish it off. Let's see what they got saying.
Understood. You may continue,
So,
Mr.
in
Sheets. I
essence,
apologize for
that
interrupting.
was kind of where I was wrapping this up here, is that I think the state's concerned of trying to stretch goalposts, or trying to attribute contact within a group that he didn't participate in, that the evidence that is established he participates in, for messages that he sends days later that doesn't concern this video. I don't think it should be attributed to him. The prejudice to him is huge, whether or not, if you admit it, the prejudice to him is huge. The probative value is minimal, because again, it's an uncharged case, it's not a crime, and it doesn't pertain to this case. And then regarding the alleged fencing, there's no evidence that makes that leap, that anything from the Kingsgate property was actually fenced or even started to be reconfigured to be fenced in this consignment store. So I think that's the gist of our opposition, Your Honor.
Understood, Mr. Sheets. Turning to State.
So, Judge, I mean, the way I understood everyone else with regard to the consignment store stuff was almost understanding that was part of the evidence of this case, especially when you consider it of, 4 adult males in their 20s. You can't just flip a Birkin or flip certain Chanel bags. I mean, would have nowhere to go for that, so it doesn't need to be reconfigured. But if there's only the population of people who are willing to even buy a Birkin, even used, is so small. You have to take that to only a few stores. But this is something that's still done in the furtherance of conspiracy. So that's what that is. That wasn't necessarily the motion, which was the video that does the plan, scheme, and preparation of these same people who were on this same text thread, who then are all found together on that same text thread later when they talk about going back to Vegas and then are found in the home. Additionally, there's needs to be kind of for absence of mistake purposes, not as far as the evidentiary admission, but there's a reason that phone was destroyed. There's a reason that some of these texts and some of this stuff was deleted, because it's absence of mistake. Mr. Butler knows exactly what that text thread is and what's on it. So, I mean, it's literally his phone. It can't come in as to all the other people in the house and not also come in under the person whose phone it actually is.
All right. At this time, I do find that the video itself is relevant, as it's highly relevant. It goes to plan, scheme, motive, probative value for that purpose is high. When I compare that to the prejudice, which is lower because this is not an actual crime charge, not an actual consummated act, it is substantially probative and it's not outweighed by prejudice. It is proven by clear and convincing evidence that we do know that it was delivered to him, and then he later talks on that chain relevant to home invasion, robbery, going to Vegas type things. So ultimately, I find that it does meet the requirements to be admitted under NRS 48.045 subsection 2, so it's granted. I'd ask though that the defense or the state edit out the racial slur at the end.
Yep, so there you have it. So the NRS 48.0452, admissibility of prior bad acts. So anyway, he had, even though he didn't exactly respond to that, he still responded in the thread in regards to other home invasions, and that is why this will be admissible in court. He will not get that thrown out. I believe it will testify on his co-conspirators based on he did not want to be lumped in with their crimes, because they did do other crimes possibly without him. But seeing that the phone was found with the individuals, I assume all these individuals were found at the same home at the same time. That's what I'm starting to figure out. Queen Raven is the mastermind of the whole thing, and he does not want to be put in the same trial, because that means all the evidence against Queen Raven will be used against Lamont Butler. And I assume Lamont Butler is not a shooter. He's not one of the shooters of CJ So Cool. No, he's not. Because I'm still waiting to hear the court date where they talk about the shooter for CJ So Cool. That's what we're waiting on. So I believe there's more to it. Maybe they'll when we gonna live stream. I'm gonna live stream the trial. That's what I'm gonna do. I'm gonna live stream the trial, and we gonna just sit back and watch, and or if it's even live stream. Hopefully they do. Hopefully they do put that on TV, because that's gonna be a big deal. That's gonna be a big deal. Well, everyday people, let me know what you think in the comment section. Does Lamont Butler get a pass because he did not respond back to the video? Brother, you are still involved. All right, everyday people, make sure you like, comment, subscribe, and we'll holler at you later.